Very well. Not today. Yes, call the list, please.
But may I have your lordship's kind leave, my lord?
47. You want to come Monday?
My lord, may I have your lordship's kind leave, my lord?
Yes. Any other physical mentioning? No? Yes, please. No. Yes. Yes, you're not. Please unmute. You're not audible.
Am I audible?
Oh, you are.
Yes, my lord. But item number 12, my lord, appearing for your lordship, my lord, we have not been served with the copy of the appeal. We have only been served with the section 5 application for condonation of delay. My lord, I'll apprise your lordship, my lord, as and when this item is called on, my lord, item number 12. I'm only, my lord, beseeching your lordship, my lord, if I'm not being able to, my lord, kindly, my lord, directs, my lord, the appellant to, my lord, serve a copy of, my lord, the appeal.
Wait for a while.
Wait, my lord, I shall wait. I shall wait.
Any other mentioning? No? Yes, call the list.
May I?
I have taken off this application, but there is certain issues. The entire application dates back to Andaman. The informant being the wife lodged a complaint at Calcutta police station. But allegations dates to Andaman. In such a case, can I maintain the application here, or I have to make an application before the municipal court needs to be trashed out with the appellate sites? Because appellate sites in Andaman Nicobar Island, it's very clear. It says case pertaining to Andaman Nicobar Island, but the entire allegation is of Andaman Nicobar Island. She simply had been to her parents' house. She lodged a complaint.
Is it a matrimonial dispute?
I'm not sure. It's pending. Matrimonial dispute is it's a 498 proceeding. Husband has already been conferred with the anticipatory bail. The petitioner here is the mother-in-law. She also approached the session court, Midnipur, Pashim Sagar, Midnipur, and it was refused.
From where has the husband been granted anticipatory bail?
By the session court at Pashim Sagar, Midnipur.
Okay.
So that's because I go by the, if I go by the appellate sites, it says that all cases relating to Andaman needs to be filed in Andaman. So I'll come back tomorrow with a copy to the other side, my lordship.
We have not received the copy.
I'm giving here now.
You not received the copy?
Not received the copy.
I'm giving here now.
What is your opinion, sir?
After going through only the petitions, I just received the copy.
Very well. Will you come back tomorrow or day after?
Tomorrow.
You need tomorrow?
Tomorrow.
For hearing, my lord, I will have to take instruction from the IO. If 2 days time may be allowed for this, then.
So Wednesday?
2 days
Yes.
time.
Yes.
By consent of the parties, let the matter appear under the same heading on Wednesdays 11.
Blair.
My lord.
Second appeal was admitted by the last bench. And since a application under Order 39 Rule 1 and 2 has been taken out, I've been directed to serve it. But they have just simply dispatched the copy of the injunction application.
It's not served.
I'm awaiting the service report.
Very well. This scan 1 of 2023 is the injunction
Yes,
application.
ma'am. Yes.
Very well. So when can you serve?
On Thursday, by Thursday, I'll ensure that service is effectively done.
So will you come back on Thursday or Friday?
On Friday.
Friday?
On Friday.
Since service upon the opposite party is not complete, comma, let the matter stand over till Friday 6th. Friday is 13th. Till 30. Very stuck.
Item 7, chapter 7 of 2023 with can.
Item 6 and 7, because item 6 was at the behest of plaintiff number 2, 3, and 4. The item number 7 is by plaintiff number 1. There is some strained relationship developed, so 2 appeals have been taken out. If will not accept this contention, so even 7 can be admitted. Same substantial question has been formulated. Same identical common judgment and decree. It will not cease that even this can be admitted on the same substantial question which the last court has admitted. I have given the copy now, just now, 2 copies.
No. The same question
My
will
lord.
be formulated and you have to serve the application.
Can application.
Yes.
My lord.
So will that be possible by Friday?
This
Because,
will be taken up on Friday. So that in the meanwhile,
because we propose to take up both the appeals together.
yes, my lord.
Yes, yes, same.
Yes, it can. My lord.
Upon consideration of the submission made on behalf of the appellants, comma, the following substantial questions of law are formulated. A and B, the same questions will be taken. Okay. Paragraph. The appellants have taken out an application being Can 1 of 2023 seeking an order of injunction upon the opposite party. Paragraph. The appellants are directed to serve copy of the application upon the opposite party. What is your usual practice? By speed post?
Speed post.
By speed post and file affidavit of service on the adjourned date. Paragraph. Let the matter appear under the same heading on the same date.
Along with the item number 6.
That is already
Yes, that is
appeared.
already fixed.
That's already
My lord,
appeared.
my lord.
On 30. Right.
Blair.
Item 8, committee 22 of 2023 can 1 and can 2. I paid for the appellant.
I am for the respondent writ petition.
Will challenge the order passed by the next signature on the ground that the judgment and decree passed by the London Civil Court in the year 2012 is regarding partition. But as per the regulation, below 200 square meters cannot be subdivided. And that about the petitioner has to approach the civil court for execution. Instead of that, he has by submitting representation to the deputy commissioner, the petitioner has sought an direction which is not provided in the, there is an impediment in the regulation for subdividing the land below 200 square meter. And that apart, this village which has been sought for to where the property situated, it has been declared as a survey area. As such, deputy commissioner has no right to subdivide. On these grounds, I have taken out this appeal.
There was a direction for affidavits.
Lord, so far as stay application is concerned, I am praying that the appeal can be taken up. Because
But,
no opposition was filed before the writ court. Based on their submission, Lordship, the order was passed by the writ court against which this appeal has been taken out. Other formalities can be dispensed with.
There was
Lordship.
an application, yes, right?
Yes, it can be taken up.
Though
That is basic
stay may be
ground.
granted. My application for stay may be granted.
Why don't we take up the appeal?
Yes. Yes, that can be.
Where is the order?
Interim order is at page number 41. Without on the first day itself, without giving any opportunity to file opposition, it has been simply disposed of with the direction to the upon the deputy commissioner to comply with the judgment and decree passed in title suit number 17 of 2012. And now my lord may see the judgment of the trial court. It is at page number 34.
Of the stay application?
Yes. This is the judgment, starts with page number 35. The decree. Here there are 4 plaintiffs and 57 dependents.
Right.
The court was allowed in favor of the plaintiffs number 1, 2, 3 and giving their shares schedule A, B and C and D.
Yes.
Thereafter, there was a commissioner who has submitted the proposal for the subdivision, which is at page number 10. Commissioner of Partition, page number 9, starts with page number 9. Here the shares have been divided in for Raja Bhagwan Das, survey number under survey number, proposed survey number 120 by 1 by 4, 84 square meter.
Yes.
There are other survey number which is below 100 square meter also, 76 square meter.
Yes.
Now, my lord, I would like to draw your lordship attention to the regulation. Which says that below 200 square meter, regulation 48. May I read, my lord?
Yes, please.
It is formations of subdivisions. Every portion of survey numbers which is held under a separate title shall be formed into subdivision.
48, you said?
Yes. Inner page number 7. Achha, first is regulation, thereafter rules. Rule 48.
Oh, that's what.
Second portion is rules,
Rule 48.
my lord.
Yes,
Formation of subdivision, every portion of survey number which is held under a separate title shall be formed into subdivision, provided that no subdivision shall be formed with an area less than 10 acres if the land is used for the purpose of agriculture. Here, this 10 acres has been amended into 200 square meter. Here, this land is also agricultural land, and the amendment I have handed over, my lord. 2 copies are already I have handed over. Hello. Copy this.
this is agricultural land.
Yes. This is a notification of 2018 and clause 6, page number 2. Clause A of Rule 48 shall be substituted as below. With an area of less than 200 square meters, the land is used for the purpose of agriculture. This is number 1 ground, Your Lordship. Thereafter, there is a notification which is at page number 29 of my stay application. Also, this is a notification dated 15 December 2011. Page number 29, annexure A4. In pursuance of notification declaring the village Calcutta as local area, and in pursuance of file number such and such declaring revenue village of Farganj Tehsil as local area under the provision of subsection 1 of 48 of Andaman Nicobar Island Land Revenue Land Reform Regulation.
Yes.
Here, my lord. 48(1) says, regulation 48(1) may be taken, my lord. This is for the purpose, notification for the purpose of revenue survey.
Yes,
Wherever the chief commissioner decides that a revenue survey of any local area should be made, he shall publish a notification to that effect. Such local area shall be held under such survey from the date of such notification until the such issuance of notification declaring the operation to be closed. Such notification may extend to all lands generally in the local area to such lands as only as the chief commissioner may direct. So here in this subject land has been declared for the purpose of revenue survey. Once it is declared, until it is closed, the deputy commissioner has no right to subdivide the land. This is my second ground, my lord. Thereafter, I have annexed the another the portion extract of regulation which is at page number 32 of my stay petition.
page number.
32 of my stay petition.
Yes,
This is 51 surplus 2. The settlement officer may either renumber survey number or subdivide survey number into as many subdivision as may be required in view of the acquisitions of right in the land for any reason. The division of survey numbers into subdivision and the appointment of assessment of the survey number among the subdivision shall be carried out in accordance with the rules made under this regulation. And such rules may provide limits either of area of land, revenue, or both, which no subdivision shall be recognized. Here, as per rule 48, it is if the land, if the proposed subdivision is below 200 square meters, there is impediment for subdivision, my lord.
Yes.
And this judgment and decree is of the year 2012. 12. After 12 years, the applicant was sitting idle without taking any steps before the competent civil court have filed this writ petition, which is not maintainable. As such, on these grounds, I pray that the order passed by learned single judge, honorable single judge, has to be set aside, and the applicant has to approach before the appropriate forum. And he has not made the other dependents. 52 dependents are there before the civil court. More than 50 dependents are there.
The order of the honorable single judge was for compliance of the
Yes.
judge.
Yes, madam. But the order of the decree could not be implemented by the respondent authorities for the reasons that in the regulation we cannot recognize the below subdivision of the land below 200 square meter if it is agricultural land.
No, decree was telling you it is something else.
We are not the party before the civil court also.
Implementation, yes. The decree was not challenged before the single judge at all.
That we don't know, my lord, the private respondents.
When you
We cannot.
come up before this bench against the order of the single judge
Single judge.
for implementation.
Yes. Because before the trial court,
Without challenging the decree itself.
we were not the party in the judgment and decree. In the judgment and decree, some private parties are there, and they have not been made as a party here.
You could have sought leave to prefer an appeal. If you're not a party to the suit before the learned trial court, you could
No,
have
we are
sought-
not the,
challenging the decree itself. You've challenged the implementation only. A very limited issue, right?
but we
Don't
cannot.
you think you need to challenge the decree by way of special leave obtained from the judge.
This is a dispute between private parties. We are not interested in the property of the parties.
But your submission is
So-
on the very
So only
primary issue
for
of law.
implementation, yes,
You are submitting on the very vital, the very primary issue of law, isn't it? It's a legal point.
yes.
So don't you think it has to be agitated before the court to deal with on merits? You have only challenged implementation of the order,
Yes,
a very limited consideration by this court.
yes.
Unless the entire decree is challenged, how can implementation only be challenged? Implementation will not, even if you get an order in your favor before us,
Yes.
we cannot set aside the decree. So that is not challenged at all.
No, I am not seeking for setting aside the decree, madam.
So what is the entire
Yeah.
prayer about? It becomes infructuous, isn't it?
They have to approach the civil court by filing an execution case, proper execution case. as per the CPC.
This
Order
has been
21.
taken in a different
Yes.
manner.
Yes,
This is not exactly an execution.
yes.
They have this is inaction on the part of the respondent
Yes.
authorities. So
So,
the High Court can deal with it.
yes, but our inaction is because of this regulation, we are unable to execute it.
You are
We
attacking
cannot.
the decree itself,
Yes.
sir, not the implementation. Once there is a decree,
Yes,
it has to be implemented unless the decree is set aside. So the proper course would be to set aside, to take steps for setting aside the decree, isn't it? If the decree remains, how can you challenge its implementation? That is consequential.
and we cannot also set aside the pray for setting aside decree because we are not the
No, no,
Party
you
in-
can before the single bench upon this leave. You have to file an application for leave to appeal, stating your contention. Yes, what do you say, sir?
No, it is rightly fallen from the issue. Because so long they do not challenge the decree, they have to prefer a first appeal under section 96 of CPC before the
Challenging
district
the
judge
decree, right.
seeking leave. They literally, Your Lordship, are prejudiced or rather aggrieved by the decree. That's the bottom line. Your Lordship.
Yes, yes.
I simply approached before the writ court saying, Your Lordship, the authorities are sitting tight over the matter, kindly direct them to execute it. The writ court directed it. Your Lordship, they have come up with this later patent appeal. Now, so the decree is staring in their face. Now, in the decree, it was a partition suit, preliminary decree was drawn up, rights were affected. Now, the very interesting part is their own man was appointed as a partition commissioner. The deputy commissioner, subordinate revenue
And the
official,
decree has been made absolute.
absolute, it was made finally in form. Now, in terms of the local regulation, I approached the deputy commissioner, you would make a necessary correction in terms of the decree. That's what is fair and simpliciter. When it was not considered, a writ court was approached. The single judge passed the order. So they have no right to say, Your Lordship, unless the decree is challenged. They have to seek leave, rightly said, in an appropriate duly constituted proceeding.
Yes, will you take instructions and come back, or will you withdraw the matter? And because I think for withdrawal also you need to seek instructions.
my lord may keep not today, I will.
Yes, because
Yes,
I have expressed my mind, so
my lord.
uh,
If
rather
anything,
we, so we'll give you another.
yes.
Unless you challenge the decree itself, I don't think you can challenge the implementation. Implementation is consequential to the decree.
My lord.
If the decree remains, there is no law which can stop implementation. The decree itself has to be set aside. If that is your case. And you are primarily challenging the decree. Yes. Will you come back tomorrow?
My lord, tomorrow.
Third learned counsel for the appellants. The appellants have essayed an order passed by a single judge of this court on March 22, 2022, in WPA 25 of 2022, directing implementation of a judgment and decree passed in title suit number 17 of 2012. Stop. The judgment and decree has not been assailed in the present appeal. Paragraph. Learned counsel for the appellants seeks to take instructions in this matter.
My lord.
Paragraph. Let the matter appear under the same heading tomorrow.
My lord.
Give the tomorrow's date on 10th. Please.
Deeply obliged, my lord.
Your Lordship, serial number 9, I am appearing for the petitioner.
Yes.
But I am for the respondent in this matter.
Your Lordship,
Able to appear today, my lord. So, my lord, he is trying to come to Port Blair by Wednesday or Thursday. My lord, moreover, that in this matter, we have been informed by the department that the copy of the appeal and the scan has not been served upon them. So, may I pray before your lordship to direct them to serve a copy.
Mr. Das, have you served a copy of the appeal and the application?
Yes. Copy has been served before the.
The copy as yet.
Your lordship, another cognizance may be brought in front of you that this matter on August 8, we have mentioned before the principal bench and the Chief Justice agreed to take up the case. Thereafter, the file got transferred in Port Blair. So yeah, I can pray before your lordship if it is possible. Can it be transferred to the principal bench as verbally Chief Justice agreed to take up the case on 8th of August?
So in that case, there's no other option. Let it be transferred. Right?
But let me know there be a direction to serve copy of it.
It has been served. It has been served, your lordship. It has been served. It has been served. We have affidavit in my hand also.
It is submitted.
Copy of the affidavit on service.
That.
Yeah, on 8th of August, it has been served before the department.
Okay.
And additional commissioner also. All the parties has been served.
Verbally. Expressed his desire to take up this matter for consideration. Paragraph indicates the above, the application be sent to the principal of this court and the connected application. Next item. The next item is also the same.
Same, my lord.
Same order, item number 10.
But this is our appeal, my lord. So, my lord, I am praying for, my lord, to let this matter be posted on Thursday, my lord, because due to non-available.
You're asking for Thursday?
Thursday, my lord.
Let it appear. On prayer of the appellants, the matter is adjourned. Yes. On prayer of the appellants, the matter is adjourned. Paragraph, let the matter appear under the same heading on 12. 12.
But 12, 12,
12th is a Thursday.
my lord.
My lord, in this matter, I
Well, this
appear
is
on
our-
behalf of the writ petitioner, principal respondents, my lord. My lord, in this, we have not been served with all the annexures in the stay petition. And most of the pages are illegible. All I pray that let the appellant serve a complete stay petition and duly paginated. Our copy is not even paginated. So my page number will not tally if I make submissions with your lordship. Let them serve a duly paginated, complete stay petition memo of appeal.
You're appearing for the principal respondents.
Yes, madam. Respond number 1, 2, and 3.
Ms. Nagi is appearing. For the respondent. But not in 12. No. Only 16 and 7. So please serve legible copies.
My lord, serve legible copies in all this matter. But my lord, what has
You
been,
have served already?
no, I'll serve. But what has been fallen from my senior is that in some of the matters where in main writ petition, your lordship has passed some interim orders. So, my lord, I don't think that your lordship be able to take up this writ petition, my lord.
Oh.
Subject to lordship's correction, my lord.
Please,
But I'll serve the copy. That
please point
direction
out the pages.
can be. But that order, I also have to check, my lord, because I only been fallen from my senior, could not be able to check it, my lord. So, my lord,
I believe I have passed some orders in sitting in the single bench. So I don't think I can take up this appeal.
My lord wants to avoid your lordship, my lord. I cannot say anything.
no, nothing like that.
Avoiding. In the sitting in the single bench, I have passed certain interim orders in this matter. So do you still think I can take up the matter?
Very innocuous orders anyway. If Lanefed doesn't want to do, my lord, I have in any event they cannot serve in such a short time. Lordship can ask them to serve complete copy and duly paginated.
Can be passed, my lord. That I will serve.
It is submitted on behalf of the respondents that complete legible copies of the
Stay petition.
stay petition has not been served upon the respondents. Paragraph, the appellants are directed to serve such copies upon the respondents at the earliest. Paragraph, it is submitted on behalf of the appellants that some interim orders have been passed by one of us, bracketed, please put my name, sitting as a single judge. One of us in this matter, comma, sitting as a single judge. Paragraph, in view of the above, the matter is released.
Matter will happen in the next circuit.
Let the matter appear.
I'm deeply obliged. I was appearing Mr. Shankar.
Till 17? He is left.
13 to 17.
So 13 to 17, same order. Ms. Nag was appearing in some of the matters.
Ma'am, certain matter, item number 16 and 17, I think Ms. Nag.
Yes, Ms. Nag, you're appearing in 16 and 17? So these are similar matters, I believe.
My copy itself has not been served, serve the copy, my lord. All. I'll serve
In
the-
16 and 17. I'm releasing the matters for the next circuit. Right? The appellants
my lord.
in 16 and 17, okay? The appellants are directed to serve copy of the memorandum of appeal along with annexure thereto, annexure/applications thereto upon the respondents and file affidavit of service on the adjourned date. Then the same order. Next circuit.
Okay.
Order was very simplistic, directly Department of Supply against this amendment by a third party has been taken.
Who is appearing for the appellants? You are appearing? Who is appearing for the appellants?
On Thursday, no, on Thursday. Let me go to the papers. I've just filed my Makala Commentary on Thursday.
So Thursday on your prayer, on prayer of the.
We are
Yes.
looking for 1, 2, 3. Official respondent.
There. On prayer of the appellant, the matter is adjourned. Paragraph, let the matter appear under the same heading on 12. Yes, next.
Item 19, Mac 35 of 2020 with can 1 of 2020.
Lord, I am for the appellant, my lord. Lord, I am not, service is not complete.
Service is not complete.
Yes.
Can you come back next week
No, Lord, it may be fixed after 2 days. I will serve in the meantime.
after 2 days? Thursday, Friday?
Thursday, it may be.
Friday.
My lord,
Since service upon the respondents is not complete, comma, let the matter appear under the same heading on 13th.
I'm deeply obliged.
Item 20, Mac 36 of 2020.
But I am for the appellant in this matter. I have to ascertain whether the service has been done. I think that service in this matter has been done, my lord. So let it be posted on Thursday, my lord, because my senior will also be there by
Will you
that
come
time.
back on Friday? Since service upon the respondents is not complete, comma, let the matter stand over till 13th. Next,
Item 21, Mac 38 of 2020.
But I am for the appellant, Mr. Binu Kumar is for the respondent. So, my lord, let this, not today, let this matter, but let this matter be fixed on, today, man, let this matter be fixed on Wednesday or Thursday, my lord. Thursday, my lord, preferably will Thursday, because my senior will be there and this matter requires to be heard, my lord, because certain order has been passed which is affecting the administration, my lord, in this matter. my lord. Okay.
On pair of the respondents, the matter is adjourned. Paragraph, let the matter appear under the same heading on 12th. 12th October.
Yours, I'm for the petitioner. It is PIL related
Yes.
to the accidents increasing in the Port Blair. And there was order for filing AO within 2 weeks, but the respondent has not done so.
But I am for
So
the.
I pray for heavy cost. It is a dereliction of duty against the public welfare. Your Honor, your Lordship, they have no respect for this honorable court, and so he should have taken in respect my petition, but he is lethargic. He has not
Give
taken-
me a minute, please. Yes, what about your affidavit?
My lord, I am for the respondent. My lord, we have drafted the affidavit yesterday only because I was not over here. So when we have drafted the affidavit, I have sent it to the department. My lord, I just praying for extension of 2 weeks to file my affidavit. my lord.
No.
The 2 weeks,
I have
because
kept
my lord,
objection.
department has to get it vetted and thereafter they will file the affidavit, my lord.
Come back next week.
The my lord,
Your-
1 week time, 1 week
Your Lordship,
extension, 1 week.
They
extension.
must come with AO within 3 days, 2 days. What is the matter? Matter about it or not demarcation of the land of the port islands. Only a small matter. He should file a AO.
When the administration has to file any document, you are aware that it needs vetting, it has a process, isn't
My
it?
lord.
You will not see.
There is
There
a procedure.
No need of the finding documents and etc. Only he has to say where my
The
complaint.
steps
is-
already taken by him and
No any steps.
no, that's why the affidavit was called.
Then
They have to put it on
3 weeks,
affidavit.
3 weeks, 4 weeks. So long.
Certain
Only
things
2
has to
days
be
is-
ascertained because one of the accidents has taken place. So we have to ascertain certain things and the local areas and all, whether there are possibilities of some precautions or not, that we have to ascertain. Malad, that's why it's taken time for
What
drafting the
taking time
affidavit.
is certain for the long one.
Can you come back next week?
My lord,
Yes?
Wonderful.
Your 4 and 5 days may be given.
but the next week.
4 and 5 days for filing AO because already he has taken.
So 4-5 days takes us to the next week, sir. I'm fixing a date in the next week.
He has
Right?
already taken 15 days.
Next week is sounding very long. If you say 4-5 days, it's the next week, isn't it? It's just like 7 days and 1 week.
Offline.
So come back next week.
Your loss.
Learned counsel for the respondents seeks extension of time to use the affidavit as called for. Paragraph, let the matter appear under the same heading on 18. 18,
Within 18, then 9 plus 9, 18, 9 days. It is beyond 7 days. So within 7 days, maybe.
17.
Okay.
And please serve an advance copy.
Okay.
Paragraph affidavit be submitted on the adjourned date upon service of advance copy to the petitioner. Next.
Item 23, WBCP 46 of 2020.
And this matter, we have, on last occasion, we have seek a time to file our affidavit to explain the delay which has been caused to file a review application before CAT, and thereafter we came up over here. So the leave was granted, my lord. Now I have to ascertain from the
For a
department
supplementary
whether,
affidavit.
whether they have filed the supplement, because we have drafted and sent it.
Who
for
is
the
appearing
petitioner.
for the respondents? Mr. PC Das was appearing virtually.
Is not there today.
Is he there today? No? The link,
Maybe urgent, I will inform Mr. Kistas.
very well. Next week,
Next week.
your supplementary affidavit is ready? No?
I think it's ready, my lord. We have drafted it and we have
You can
sent it
come
for
back next
filing.
week,
my lord.
next week with
My lord, next.
on prayer of learned counsel for the petitioners seeks extension of time to file the supplementary affidavit as sought. Paragraph, learned counsel for the respondents also seeks accommodation. Paragraph, that the matter appear under the same heading on 18th.
Item 24, I am for the respondent.
I am for,
Pressing for hearing of this application, my lord.
my lord, I
For
am
the
for
sole reason that my client is 75 years of age. He is suffering from cancer. One leg is in grave. So urgent.
You are appearing for the appellants? Yes.
applicant, but let this matter be fixed on Thursday, my lord, in that case. my
On
lord.
that Thursday,
Because
my lord, no adjournment, my lord.
All matters,
I know
can be
adjournment.
all matters be taken up on Thursday, sir.
I have personal difficulty because I am not on the panel, so if something adverse will go, my lord,
Right.
senior will be affected, so my lord, that's why I'm praying.
You are appearing for the respondent.
My lord,
What is the appeal about?
your appeal is about the order passed by the tribunal regarding the service, my lord. I was appointed long back, my lord, in the year 1984. I was holding PhD degree. My appointment was purely on order basis. I served for 5 years. After 5 years, I was regularized. So all pay benefits was given. There is a UGC notification is there. At the time of initial appointment, if I possess doctorate degree, I am entitled for advance increment. That increment was not given. Similarly placed other lecturers, my lord, approached the learned tribunal. Learned tribunal passed order in their favor. It was granted to them. I also approached the tribunal asking for benefit of that judgment. The tribunal out of 2 judges, 1 judge is against passed and against me. Another judge is dismissed my original application. Matter was referred to 3rd judicial member. 3rd judicial member also opined the order of the judicial member. He affirmed the order of the judicial member. Against that, my lord, they preferred this writ petition, challenging the order passed by the tribunal. It is only grant of the benefits, my lord, for a period
You are
of 5
seeking
years.
parity.
Parity.
There are
Already decided.
conflicting
And
decisions.
what about the
so-
pro forma respondents? Who is appearing?
Performer,
Not necessary.
Not
Not necessary.
I am the original applicant before the tribunal.
When will you come back?
I am ready, my lord, today also.
Thursday, Friday, whenever your lordship meeting. we can do.
Friday?
My client, my lord, retired 12 years before.
On, come back on Friday. On prayer of the affidavits are required, no?
Not required. It's a
Right
right
appeal, my lord.
On prayer of the petitioners, the matter is adjourned. Paragraph that the matter appear under the same heading on 13th.
My lord, 13, they should not pray for time, my lord.
Not,
When my client
not
is,
going, we are ready with this.
Please be ready on the 13th.
The case of the petitioner is that there was an allegation by a girl child, that is a student, that she was molested by the petitioner. Now, your lordship, criminal case was also initiated, departmental proceeding was also initiated. During the departmental proceedings, she has deposed that when the examination in chief was done by the presiding officer, she deposed that she was caught cheating by the teacher concerned, and that is the reason why she was lost a false complaint. She specifically stated, and she has stated that she was caught when she was cheating. The teacher has pulled her from the back the shoulder. And then she said, it is a false complaint which I have lost. I should not have done this. So she has deposed clearly in that term. And all other witnesses also have supported in that manner. The complaint was falsely lodged by that. Even the mother of the petitioner, everyone submitted. Despite such fact that tribunal, there is no evidence. Despite such fact that tribunal, the disciplinary authority had been liable and the exclusion process.
Have you served? Have you served?
My copies, sir, we have just today received the documents, mother.
Let it be on Wednesday, also, because this is the WPC.
I'll let it be on Wednesday. no
Wednesday?
problem.
Wednesday. On their ground.
That's day after?
Yes.
Yes, of course, on their ground. On prayer of the respondents, the matter is adjourned. Paragraph that the matter appear under the same heading on 11.
Obliged.
Hello, I'm appearing for the appellant.
I'm for respondent.
During the time of hearing of the stay application which is filed by me, not challenging an award passed by the collector land, challenging an award passed by the Honorable Additional District Judge. So this court has directed me to assess the compensation which has been enhanced. So my lord, it has been already assessed and sent to the law department for making. I pray that it be taken on Monday, my lord, so that
You are appearing for the appellant?
the appellant will. I have instruction that it will be during 2-3 days it will be received. Because the assessment, it is in a big sector history, not from the 2004 to till 2023, it has to be assessed. It has been already sent to the
When can you come back?
Monday, will not.
Monday.
Blair.
It is submitted on behalf of the appellant that in compliance with the earlier order of this court, the detailed calculation of the amount to which the respondent is entitled has been sent to the department for vetting.
Yes.
For vetting. Stop Learned Council seeks accommodation. Paragraph that the matter appear under the same heading on 16th.
Blair. Item 27,
Lordship, I appear for the state. It's a state appeal. I don't know if the, I've got the paper book. Other side is appearing or not, I'm not sure.
Have you served?
It has been served through registry. It is against acquittal, so he must be informed about.
I don't find that the paperwork has been collected by the respondent.
It has to be your lordship.
Will you wait till the next circuit? Because in these 2 weeks, I don't think it will be possible.
Lordship.
It cannot be ascertained whether the respondent has collected the paper book from the office of the registry stop. The respondent is also not represented. Paragraph, the matter be placed before the next available circuit bench.
My presence may kindly be noted here.
Yes. Sure.
I go for the state, my lord, for the respondent state.
I am for the appellant, my lord.
Paper books are complete?
Paper books are complete, my lord.
Appeal against conviction.
Yes,
An appeal against conviction.
yes. Will you start?
Just not today, my lord. We'll start tomorrow.
You are not ready today. What is the matter about? Can you tell us in short? Or you are not ready? You want to come back?
I'm not ready.
302 conviction.
Tomorrow, my lord.
302 conviction.
302 convictions. Circumstantial evidence. Strangulation of the wife allegation that he has killed his wife. Circumstantial evidence, he fled away from the islands. He was arrested subsequently. On the basis of circumstances, the court held that the chain is complete and conviction was there.
Tomorrow,
Tomorrow.
not today.
Item 29, CRA moving forward when you want to do with trying to.
IPA for the state, your lordship.
This is an appeal filed by the appellant. During the time of hearing, the honorable court has suspended the sentence under the POCSO Act. He has been convicted for life. And subsequently, this honorable court has also enlarged the accused on bail. And during the course of argument, my lord has been directed us to file the marriage certificate between the victim and the accused. They have filed an.
Oh, they have married subsequently.
They have been having a
Subsequently.
under a relationship because they are in a love relationship. So subsequently, the only.
So are you ready with the marriage certificate?
No, I filed it. Not the. Fixing it on Monday, I will call both the parties also. They are from Mayabandar.
So you will come back on Monday?
Monday, I will call them
Yes.
also in the court. Both the victim as well as the accused.
Does it exonerate your client?
No.
I know, madam, just 2
The
points.
way
I
the
will make-
cross-examination was done, your lordship.
I will not stand on that.
That was not.
Because there are 2 aspects. One is that with regard to the age. At the time when the incident was happened, that whether the age of the victim was on 18 years, below 18 years or not. The second aspect is no ossification test was done. When she was pregnant, when she had went to the hospital for delivery of the child, then they found that there was 6 months lax to for 18 years. So they, on the basis of the MLC medical legal cases, they have been registered in FIR. The accused has been arrested. And in the 164, she has admittedly, she has initially voluntarily said she is an 18 years old. So, let me fix on Monday what I just said to this.
Please see that it doesn't lead to a 306 or a 302.
It's,
These marriages are very dicey.
yes.
Monday?
Okay.
On prayer of the appellant, the matter is adjourned. Paragraph, let the matter appear under the same heading on Monday 16.
Item 30, CI 5 of 2020.
IPA for the state, your lordship. Here the matter, the accused is in custody.
Who
So
is
there is a
accused, appellant?
jail appeal. This is the jail appeal. And the learned counsel was appointed by state legal authority.
Who is it?
I believe Mr. Rajesh was appointed, but I don't find him because maybe he's in the notion that today is the first day.
Sir, shall I
This
make it
matter-
not today?
Yes, it can
Right?
make it as
Let
not.
let it be not today.
Otherwise, it is ready for hearing.
What is the offense?
POCSO Act
POCSO.
happens to be the biological father of the victim.
Not today.
Not.
Item 31, CRA 5 of 2022.
Yes. This is just like this is the state appeal, your lordship. It's a very recent brief.
Service done?
I believe not done. I'm not sure because it was recently handed over to me. This was dealt by learned counsel, Mr. Tulsila.
So will you come back next week?
We'll come back on next week.
An earlier order records that service has been effected,
Okay,
despite which the respondent has
not
not appeared.
appearing.
Will you come back next week? Let us see.
Lordship.
None appears for the respondent. Paragraph, let the matter appear under the same heading on 18.
18th.
Madam, please check in the meantime. Right?
Lordship, I'll check.
Yes, next.
Item 32, CRA 7 of 2022.
Here also I appear for the state. Learned counsel, Mr. Aditya Santos appearing.
Here also no one for the respondents? Thanks. None appears for the respondent. The same day,
Lordship.
paragraph, let the matter appear under the same heading on 18th. Please complete service in the meantime, if not done already.
Item 33, CRA, 12 of 2020.
Here also I appear for the state, same position I believe. This all matters of Maya Bandar. That is the reason the service is not been effected. All accused person hails from inter island.
So here also service, because service is not
Service is
affected.
not.
Since service upon the respondent is not complete, comma. Let the matter stand over till 18th. Let it
18th.
appear on the same day.
Item 34, CRA, 2020.
In this matter, I am for the appellant,
I appear for the
fixing the
state.
matter on Monday.
Monday. Time.
What is the conviction of?
It's conviction of
Like-
offshore. Like, initially, I filed this appeal, my lord. What has happened thereafter when the paper book was supplied to me? The parents of the accused victim convict came and they took the brief back from me. Recently, they have handed over it again back to me. So I say that,
They cannot take a decision.
no, that is the difficulty for me, even like I was not ready since the matter was taken back from me. If it is on Monday, I will get ready by that time. There is no inconvenience to the other side on behalf of the.
So Monday,
Lordship.
on prayer of the appellant, the matter is adjourned. Let the matter appear under the same heading on Monday. On 16th.
Item 35, CPN 25 of 2020.
I am for the respondent in 35 and the petitioner in 36, my lord.
Let it be tomorrow, not today.
Not today?
Tomorrow, day after tomorrow.
By consent of the parties? Yes. By consent of the parties, let the matter appear under the same heading on the after is 11. On 11. 35 and 36, same order.
Item 37, CRA, DB.
I appear for the state.
Also, Mr. Binu Kumar is appearing.
In fact, 35 is with 36. So it will be governed by a common order. Yes, 37.
37, CRA, DB.
Here also, Mr. Binu Kumar is appearing. Let it be next week, Monday.
I appear for the state.
All matters and paper books ready?
Paper books ready.
Let it be Tuesday.
Tuesday.
All the matters appearing on Monday.
Madam.
On prayer of the appellant, the matter is adjourned. Let the matter appear under the same heading on 17th.
Assign name. Brief assign name.
Item 38, CRA, DB 11 of 2022.
In this, my lord, I am for the appealant. This matter is ready. I am ready.
Who is appearing for the state?
Lordship, I don't have the brief, so I don't think so.
It's a case of also most probably my learned sister will appear because she is the prosecutor.
I don't know
special
whether
prosecutor.
it's, hey. Paper book. hai.
So will you come up on Tuesday?
I have no paper book of this case, your lordship. I don't know whether it is lying here, if it can be given to me.
Is it lying here?
Nahin.
Or the department? Paper is not there.
We'll find out.
Is it someone else who will do that? You appeared on the last occasions, even when it was admitted.
But I'm not with the paper book.
So will
here.
you come back
That is
next
the
Tuesday
difficulty.
in that case?
I'll find out where the paper book is lying.
Next Tuesday?
Next Tuesday.
On prayer of the state, the matter is adjourned. Paragraph, the matter appear under the same heading on 17.
Both in item 13 and 14 of the variance notice for the respondent, both matter we're going to take time for hearing. So preferable if your lordship may fix this matter next week or any day.
You are praying for the respondents,
No, I am for the.
but your submission is being made on behalf of the respondents. You are appearing.
No, Mr. Binu Kumar is there.
On prayer of the respondent, the matter is adjourned. Let the matter appear under the same heading on 18. 18. (39) and 40, same order.
That will be tomorrow. Mr. Binu Kumar is appearing
I am appearing for respondent.
tomorrow.
Not today only.
We have filed the report, as directed.
Have you served?
No, no. Let-
So let it be not today only.
I appear for the respondent.
Who is appearing for the appellant? No one. No one.
43.
None appears for the appellant. Let the matter appear under the same heading on 19th.
Obliged, Your Honor.
Your Lordship, in this matter, I appear for the appellants, the applicant here in Your Lordship. This is a mandamus appeal accompanied with a leave to appeal application, Your Lordship. An affidavit in opposition to the leave to appeal has been filed by the respondent 8 and 9. And Your Lordship, a reply has to be filed and serviced yet, Your Lordship. So I pray before Your Lordships to place this matter on Monday or Tuesday, Your Lordships, for
Tuesday.
hearing. Tuesday, Your Lordships. Obliged, Your Lordship.
In item number 44, both the items are tagged.
He is the applicant.
He is the applicant.
On prayer of the applicant, the matter is adjourned.
In item 41, I am respondent. Your Honor.
And let the matter appear under the same heading on 17.
17.
Yes, Your Lordship. Much obliged, Your Lordship.
I am for the administration in this matter.
43 is along with 40.
Madam.
Get together.
But in both this matter, there are different sets of advocates for the
I am appearing for respondent number 1 and 2, my lord. You, please.
I am there for the appellant. But there is one difficulty. The counsel for the writ petition before the writ two, who is the private respondent hearing, he is undergoing surgery in his leg, Mr. Vijay Kumar. There cannot be a dispute on this fact by the other adverse side.
Agreed.
He is taking treatment in mainland Chennai, I am told. So, no alternative arrangement has been made, but these are the facts, which I want to bring.
So do you want it before the next circuit in
Next
that
circuit.
case?
Yes, that
My
can
lord.
be done. There's an interim protection that needs to be extended. This court granted at the first instance
Right.
when the appeal was filed.
Let it be extended till 20th December.
Yes.
My lord.
It is, we have been informed that learned counsel for the private respondent is undergoing surgery / treatment and requires some time to resume normal life. Paragraph. In view of the above, let the matter appear before the next available circuit bench. Paragraph, the interim order granted earlier is extended till 20th December or until further orders, whichever is early.
Obliged, your lordship.
Just a minute. Resume normalcy.
My lord, in this matter, Mr. Mohammed Tabi is appearing for the responding matter. My lord, due to some medical emergency, my lord, he is not in station. So I pray for next circuit.
Yes. On prayer of the, for the respondents,
Responding.
on prayer of the respondents, the matter be placed before the next available circuit bench.
48, matter of 2023.
Lord, I am for the appellant in this matter led by learned ASG Mr. Vikramjit Banerjee, my lord. Now, my lord, due to some of the matters of him before the Honorable Supreme Court, my lord, he has requested me to pray before your lordship to, my lord, fix this matter on next week, my lord, on any Wednesday, Tuesday or Thursday, my lord, because on Monday and Friday he had problems because there are matters before Supreme Court, my lord. He is doing this through the preferably, my lord, Wednesday.
Wednesday, very well, very well. That is the respondents, on prayer of the respondents.
No, my lord, I am for the appellant, my lord. He is for the, my lord, actually, Mr. Binu Kumar is for the respondent, but he.
On prayer of the appellants, the matter is adjourned. Paragraph, let the matter appear under the same heading on Wednesday is 18th.
18.
Item 49, Mac 18 of 2023.
I am for the respondent. I am ready with the matter. Who is appearing for the. When will you come back next Wednesday? If you miss this week, it's difficult to take a hearing.
Wednesday, he is coming on Wednesday, this Wednesday. So let it be this Wednesday.
Day after tomorrow?
Yes, day after tomorrow.
He's asking.
No, that was, this matter was almost heard in the next, last circuit. But due to certain reasons, it could not be completed. So they are aware of the, all facts. Nothing new is to
A
be.
de novo hearing is required.
Yes, that is true. But it's not a new matter. That's what I am submitting. They have already argued the matter.
Yes, when can you come back?
Thursday it may be fixed.
Thursday?
Yes, this Thursday.
On prayer of the appellants, the matter is adjourned.
12.
You are the respondent. Yes?
Respondent.
Let the matter appear under the same heading on 12.
Obliged.
50 18 of 2023.
I was Mr. Munda is appearing for the petitioner. He has requested to fix on Monday because in this week, due to some personal difficulty, he will be unable to appear.
Who is appearing for the, you are appearing for the respondents. On prayer of the petitioner, the matter is adjourned. Paragraph petitioners. No, there's only single petition, the petitioner. Paragraph Monday. Let the matter appear under the same heading on 16th.
Obliged.
51, 20 of 2023.
This matter is
Thursday.
Other side again the same problem.
This Thursday.
On 12.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 12.
Obliged.
This is for the 7th time I'm before this court challenging the order of the learned tribunal. Now, the case has some peculiar facts. Not a government servant working under the police department as constable encroaches a revenue land here. Not in Andaman, there are schemes being promulgated to regularize encroachments over the revenue land. I filed a suit. When it was not done, suit is pending. Interim protection has been granted. My employer set the disciplinary proceeding in motion. At every round of stage, I have challenged it.
On the ground of such encroachment.
Such encroachment. They termed it to be a misconduct. Ultimately, the punishment, major penalty was imposed for dismissing me from the service. So, mainly on these two count whether my encroachment over revenue land would tantamount to misconduct under the CCS rules and the punishment in disproportionate. On these two coins, I would be arguing, I would be saying this has to be taken up during this circuit. He's out of service. In 2-3 years, he would be retired. For the last 5 years, he's fighting. Some precedent to the matter, Lordship. This has some peculiar facts, Lordship. Suit is pending. The civil court insists of the suit to decide whether I'm an encroacher of the revenue, whether it can be done. On that count,
What is the subject matter of the suit?
Suit is seeking declaration, possessory right. My right has been ripened, Lordship. For establishing it, I filed the suit. Suit is pending. Interim protection, just it's a counterblast. The
Have you annexed all the relevant documents?
everything is paper books have been filed.
Yes.
So this it be fixed as per the Lordship meeting after this witness.
Thursday.
Not with certain upgradation priority,
This
because
Thursday.
this is in the last matter.
Right.
I don't know whether this
Because,
matter be able to-
because my lord would be sitting for this lesser period. By the time the matter list would be exhausted, this matter would again go back to the next circuit. It's my humble prayer. This is
In that case, come back on Friday.
right.
But Thursday, a lot of
Right.
matters are going to be.
I think this matter will be a short matter, not very long.
Yes. So some priority.
Upon hearing your submission, that is my prima facie opinion also, let us see.
Madam.
On prayer of the respondents, the matter is adjourned. However, let the matter appear under the same heading on 13.
Some upgradation since it's coming.
Let us
then-
see, 13, too many matters have not been fixed.